Good evening, and welcome to the Brennan Center for Justice's fifth event of the spring season. Tonight's event is titled The Legacy of Justice Scalia, featuring Rick Hasen, a professor of law at the University of California, Irvine, and Joan Biskupic, a leading journalist and CNN legal analyst. I now invite you to silence your cell phones so as to not disrupt the event. We would, however, love to connect with you on social media. You can find us on Facebook and Twitter using the handle @BrennanCenter and our hashtag BrennanCenterEvents. We also would like to let you know about two great events we have coming up in collaboration with Carnegie Hall's festival celebrating the 1960s. Tomorrow, in this very room, we will have a panel on voting rights then and now. And a couple weeks from now, on March 20th, we will also have a panel discussing the legacy of the programs of the Great Society. You can also check out our other events by taking one of these flyers, which you can find in multiple places in our lobby. Professor Hasen has graciously agreed to sign copies of his new book, Post-Program. If you would like an autographed copy, you can purchase one at our sales table and then head over to our signing table with Professor Hasen. We will begin in a couple of minutes, and I again ask that you please silence your cell phones, enjoy the program, and have a terrific evening.
Hello and welcome. On behalf of the Brennan Center for Justice here at NYU Law School, I want to welcome you to this very timely and hopefully provocative book talk. My name is Wendy Weiser, and I direct the Democracy program here at the Brennan Center. As many of you know, the Brennan Center is a nonpartisan think tank and public interest law center that works to revitalize, reform, and when necessary, defend the systems of democracy and justice. And that includes the independent judicial system, a core protector, a linchpin of our constitutional democracy. It is the judiciary, and especially the Supreme Court, that interprets and enforces the constitutional boundaries and rights. It guarantees equal justice, and it is the ultimate guarantor of the rule of law in our democracy. And at a time of increasing encroachments on those boundaries and rights that traditionally constrained government actors, people are increasingly looking to the courts as the protector of last resort. To maintain the legitimacy that they need to play this role, the judiciary typically tries to stay insulated from politics. It operates under rules of decorum, respect, and fairness. It prizes careful fact-finding and reason. In other words, the courts try to stay boring and above the fray, but not Justice Scalia. As Professor Hasen writes, he challenged the established legal order, disrupting the Supreme Court, like Speaker of the House Newt Gingrich disrupted the House of Representatives in 1994, and Donald Trump disrupted the presidency in 2016. He was a deeply funny and sharp-witted man who changed the way we think about statutory and constitutional interpretation with his ideas of textualism and originalism, but more importantly, changed the way we think about judging. Through the force of his personality and his colorful language, he made the Supreme Court a much more polarized institution overall. And in doing so, he moved the boundaries of not only what we think of appropriate conduct in the judiciary, but in the legal profession overall, perhaps contributing to the decline in overall faith in the independence of the judiciary. So more than his jurisprudential contributions, it is Justice Scalia's polarizing influence that we need to contend with and hopefully move beyond today at this time. And there is no one better to explain how we got here than Professor Rick Hasen, Chancellor's Professor of Law and Political Science at the University of California, Irvine. Rick is one of the nation's leading experts in election law, campaign finance regulations, and the courts. He is co-author of a leading election law casebook, the founder of the quarterly Election Law Journal, a member of the American Law Institute, and the leader of the must-follow election law blog and listserv. He is a shockingly prolific writer with more than 100 published articles on election law and multiple books. And we are delighted here at the Brennan Center to host Rick for his third book talk in recent years. He consistently manages to put out timely works on whatever the critical issue that's challenging our democracy of the moment, and his latest book, Justice of Contradictions, Antonin Scalia and the Politics of Disruption, is no exception. We are also grateful that CNN legal analyst and Supreme Court biographer Joan Biskupic is here to moderate. Joan has covered the Supreme Court for 25 years and has written several books on the judiciary, including a biography of Justice Scalia, and she's currently working on a biography of Justice John Roberts. We are very honored to be joined by two such incredible giants in the field, and so without further ado, I'd like to turn it over to you for a real interesting evening. Thank you.
Thank you, Wendy, and thank you all for coming here. And thanks, Rick, for giving us this great opportunity to talk about one of my favorite justices, too. As Wendy said, I'm actually now writing a book about the Chief Justice, and I would say rarely does a day go by when I think, I'd like to be writing about Justice Scalia again. He was so interesting and accessible, and I ended up having 12 on-the-record lengthy interviews with him. And I like to tell the story about how he first agreed to this because it tells you a little bit about his personality, a personality that certainly Rick will reveal for us today. When I first started working on my book that came out just about a decade ago, he said, you can talk to all my friends, you can talk to the justices, but I don't really want to talk to you at all. I don't want to help you with this enterprise. And I said, just be cool. We could, just wait and we'll see. And I happened to run into the justice at a wedding. I should say that we did not run in the same social circles, but we had one friend in common, and that friend happened to get married. So I ran into the justice at a wedding, and at a wedding, of course, we're not carrying multiple tape recorders and a big bag and pen and paper. And he was drinking a lot, and we were drinking, and I said, he asked how my research was going, and I said, I've been to the archives in New Jersey, tracking your parents when they first came over here, doing a lot with your father. As Rick knows, his father was a professor of Romance languages at Brooklyn College. And I said, Justice Scalia, I found the very first time that your father was mentioned in the New York Times, and it might be of interest to you that it was when he won this prestigious fellowship as a very young man to study over in Florence and Rome. He had come to America not knowing any English and then ended up getting his PhD at Columbia. And I said, and in 1934, he won this great honor. And Justice Scalia, always the man who would one-up anyone, said, yes, but did you know I was conceived on that fellowship? And I said, no amount of research would ever have gotten me that. So we will now learn about what he then did after little Antonin Scalia, born in March of 1936. So we're actually on his 82nd birthday month here, what he went on to do. And we're happy to have Rick with his new book that here. We're going to be holding up at intervals. And I thought I'd start first, with a basic question of all the things you could be writing about, Rick, with your very heavy workload, 9 justices, other retired justices. Why Justice Scalia?
Great question. Let me first say thank you to you, Joan, for making the trip to come here, and to the Brennan Center, and to Wendy and Michael and the staff for putting this together. You've been very gracious host to me now for a third time, and I appreciate it, and especially given so much that's going on now, it's hard to just keep track of all the news of the day. You got on the subway and Thad Cochran had announced his retirement. Everything's moving so fast, so it's nice to take a moment back to reflect. So where did the book come from? So about 5 or 6 years ago, I came up with a book project that I was going to call the Scalia Court. And it was going to be about how Scalia was the most influential justice. And I showed it to some people, and I thought about it, and I felt like it didn't work. I didn't really capture the justice in what I was trying to do. And so I put it aside, ended up working on the other books that I ended up writing. And I'm just so fascinated with Justice Scalia. I thought he was the most interesting person on the court, and I thought he was influential in very important ways that were not really captured by traditional measures. So I wrote to our friend and my then dean, Irvine. I sent him an email one weekend morning, and I said, I'm going to pick the Scalia project back up. Do you have a little bit of time for me to pick your brain? And he wrote me back an hour later and said the justice just passed away. It was that day, February 13th, 2016. So I said, now I've got to write the book. And so with that chapter closed, I kind of take a reflection and ask, I know in 50 years how people are going to look at the justice may look very different than it does today, but how do things look a few years out? And I wrote the book not only, it's not a biography. In fact, the best biography of Justice Scalia, as I say on my opening page, is Joan's book. It's kind of a biography of his ideas. And so it's not just about what he did, but about what his influence is going to be on the Supreme Court. And my pitch is, I think, that he may be more influential in his death than he was when he was alive.
Okay, so let's talk about the idea, and because I know we have several people who have legal backgrounds here, but we also have people who don't, and just to let them explain the idea of originalism and what Justice Scalia meant by that, and maybe even mention how what Justice Scalia meant by that isn't what other conservatives even meant by that, like, for example, Justice Thomas.
Yes, and there was my chapter on originalism, I start with an oral argument in a case involving the constitutionality of California's ban on violent video games. And Justice Alito, who's also conservative like Justice Scalia, but not an originalist, made a snarky comment. He said, what Justice Scalia wants to know is, what did James Madison think of video games? Did he enjoy them? And Justice Scalia pushed back and said, no, that's not what I mean. I want to know whether anyone at the time of the writing of the First Amendment would have thought that speech about violence would have been excluded from the First Amendment. And so Justice Scalia was very careful to say that what he was trying to do was not to get into the head of the founders to figure out what original intent means, but instead what he called original public meaning. And what he was trying to do was figure out what an ordinary person, ordinary intelligent person at the time that either the Constitution was written or at the time an amendment was passed would have thought that the words meant. And so that's what he was trying to do. Now, we'll probably get into this later. He didn't always stick with that. So sometimes he was much more of a textualist. Sometimes it was really, what did the words say? And at other times it was, what did people at the time think? So if you ask, for example, whether the Eighth Amendment, which bars cruel and unusual punishment, would allow today for flogging, at one point Scalia said, no, I wouldn't go that far. He called himself a faint-hearted originalist. And then towards the end of his life, he took that back and said, there can be laws that are stupid but constitutional. He used to have, I think, a stamp that said stupid but constitutional that someone gave him. And he said, I would have upheld. So he kind of sometimes played it both ways on what he meant. And sometimes, as I'm sure we'll talk about, he ignored his originalism entirely. But the idea is the Constitution, as Scalia liked to put it, is dead, dead, dead. And he rejected the idea of a living Constitution whose meaning changes over time as societal values change.
And this is where he had so much of an influence on young people. He helped found the Federalist Society. He was the faculty advisor. And a lot of students, it was Ronald Reagan had just come into office, and there was a real conservative movement politically. And these young students thought, why don't we do it legally? And there was Antonin Scalia with all that charm, all that humor, all that devotion to his brand of originalism. So even though, as Rick says, other conservatives don't quite subscribe entirely, some go much further, some go not as far, many, many law students sort of earn their JDs on originalism. You repeated the quip of Sam Alito and Justice Scalia's response to it, and a little bit about that was Justice Scalia saying, oh, no, I'm the funny one. You can make a joke about James Madison in videos, but I'm the one that gets to tell the jokes. And I think we should sort of let people know what it was about the way he communicated that made his message so interesting and attractive to people, for better or for worse. So, and you do a lot with that in the book. You talk a lot about his lively writing. And why don't you just, lay out some things that people should know about how it worked and didn't work in a broad way, and then we'll talk about a couple examples.
Sure. So I think he was, when he was on the court, the most engaging writer on the court. I would say someone like Chief Justice Roberts writes very clearly, and you understand what he's saying. But Scalia wrote with style. And I was just at an event at the National Constitution Center where one of the speakers who has just published, Ed Whalen, who had just published a collection of Scalia's speeches, talked about how when Scalia would draft opinions, he would read them out loud as they were in draft because he wanted to know what they sounded like. And I thought, that's a way to be an engaging writer. If you're trying to write with a conversational tone, put it into language that people understand. And so he was nimble, he was direct, but he didn't dumb things down. You know, if he had a complicated idea, he would explain it. He would use analogies. So in some ways, you know, he contributed to the court becoming a more accessible institution because you would actually pick up his opinion. I'd say this is true of Justice Kagan as well now. You could pick up the opinion, know nothing about the subject, and by the end you understand what's going on. And that's not true, for example, you pick up some of the other justices' opinions, and they're much denser and they're harder to read. But there was a downside, too, to Scalia, which is that he was the nastiest justice by far. So I did a study where I looked at how often a justice's opinions would be called in a law review article sarcastic or caustic. And it turns out that Scalia's off the charts. I literally have a chart in the book. Scalia had an average of almost 3 opinions per his year on the court described in that way, and the next justice down was like a 0.3. So he was a 2.78. So how do you quantify this, this kind of sarcasm? He would call other opinions irrational. He would say they couldn't be taken seriously. In the Obergefell case, which I think we're going to talk about, which was one of the same-sex marriage cases, he dropped a footnote where he said if he had to join in, and then he quoted part of the Justice Kennedy majority opinion, which was a living Constitution kind of reading of the Constitution. He said, if I had to do this, I would hide my head in a bag. And and there's really nothing like this in any other Supreme Court opinion that I could find in modern times. He said that you know, the great writings of the Supreme Court had been reduced to the aphorism of a fortune cookie. But I think what was most troubling about when he would engage in this caustic kind of speech is that it was not just a kind of an ad hominem attack, although he did say that Justice Kennedy's opinion was as egotistical as its style was pretentious. So that's sort of ad hominem. But it was aimed at delegitimating the court, and this goes to some of what Wendy said in her opening remarks, which is that when Justice Scalia said, this is how things should be decided, he believed it was his way or it was illegitimate. And so even though he said he was choosing his theories of originalism, textualism to add legitimacy to the court by rejecting other methods of interpretation and saying that what the other justices were doing was politics and not law, I think he actually undermined the institution. And it was his language that really sent that message, and sent that message to a generation of law students who would eat up his dissents, which he said he wrote his dissents for law students. He wrote them to be pizzazzy. That was his word. So that law students would read them, so that law professors would stick them in a casebook so the students wouldn't fall asleep when they're reading. Charming, but full of venom. And you know, it was kind of a dangerous combination.
Well, it's funny you use the phrase. I'm just going to read the quote from your book because it's so him, and it's one of his last major writings before he passed away. It's in the summer of 2015. He says, if even as the price to be paid for a 5th vote, I ever joined an opinion for the court that began, and again he does kind of some highfalutin language of Justice Kennedy, I would hide my head in a bag. And then he goes on to say, the Supreme Court of the United States has descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie. And I want to just hit that fortune cookie. When I was a law student, Wendy and Rick and I were talking about our years in law school, and you know, frankly, when LexisNexis was first coming in, and I remember I could put in LexisNexis like 2 words and get the Justice Scalia opinion. You know, like fortune cookie. How many opinions have fortune cookie in it? How many opinions had junior varsity Congress? Remember the kind of things he would say? He was so original, but as Justice Ginsburg said of how he turned off Justice O'Connor, it had its consequences. He lost influence not just in the more recent times, but earlier on, because some people just didn't want to take it. Now, Justice Ginsburg, of course, could take it and would just brush him off as, that's Nino. One of her best lines was, sometimes I'd like to strangle him, but I do love him. But so it was enticing to law students. Certainly, it made him a bit of a hero. But you say that it was contagious in some ways, even on the court. And let me quote the justice who you use as an example of someone who might not have been so caustic herself if Scalia hadn't laid the groundwork. And this is Elena Kagan, who's a fabulous writer, just as Rick described the Chief Justice, who's a superior writer. In fact, that's another thing I think. Not only do I sometimes think, I wish I were still writing about Justice Scalia, I think, I wish John Roberts was writing this book, because he is a very, very clear writer. And he has some zingers more and more, frankly, also. But at one point, Justice Kagan is responding to the Chief Justice in an Arizona campaign finance case, and the chief has talked about finding a smoking gun. And she responds, "The only smoke here is the majority's, and it is the kind that goes with mirrors." And then Rick writes, "It's hard to imagine Kagan, a very talented writer, writing so nasty a response had Scalia not paved the way."
You don't buy it?
I don't know.
Well,
I didn't. First of all, in the whole scheme of things, I didn't find that one to be too nasty.
well, there's a scale of of nastiness, but I do give other examples. Justice Alito. One example which comes in at the very end of the book that I had to kind of edit in, two from Justice Gorsuch. One was, he said in the oral argument in the partisan gerrymandering case from Wisconsin, he said, can we talk about this little matter, the Constitution, as though the rest of the justices were not. And in another opinion on debt collection that he wrote at the end of last term, he said, if there's a problem with the statute, there's a way to deal with it. It's called legislation. And it's a kind of hectoring, it's a kind of lecturing to others that there's a right way to do it, and it's done not in a gentle way. And I think that that I don't know if the lack of civility is causally only Scalia, but I certainly think he contributed to it. And one of the things I point out is that although in the 1960s there were some justices who were public speakers, like William Douglas would speak a lot about the environment. Arthur Goldberg would give speeches for United Jewish Appeal. They did not speak about their jurisprudence. They did not criticize other justices. And then the number of public appearances of the justices falls off a cliff. And then Scalia comes on the court and they go up. And they go up, and Scalia is not just making appearances, he's telling people who don't like Bush versus Gore, for example, get over it. And I actually think that I blame Justice Scalia for Justice Ginsburg's intemperate comments about Donald Trump. I don't think she would have been out there and been so forthright in her political beliefs to a public audience if it were not for Scalia paving the way in being not just a justice who decides cases, but one who is a public intellectual who's weighing in on the issues of the day.
Well, I don't fully agree with you on that one, but I want to, because I think that we have more law professors on the court too, and law professors.
We can't shut up.
That's so funny. That's what I was just going to say. They like being out there. They like being out there, and they mix it up a little bit more. So I don't know if it was the Scalia effect as much as it was the law professor effect, and also the effect of getting a little bit older and feeling less guarded. And that's the other question I was going to ask. Justice Scalia, one of his most famous dissents, for those of us who made a habit of collecting them, came just in his second term, and it was in the independent prosecutor case, where he was referring to the independent counsel statute that the majority upheld. This was what enabled Ken Starr, as a matter of fact. But he was talking about the majority's opinion upholding the independent counsel statute that we don't even have anymore. But he, in his lone dissent, he said, some wolves come to us dressed in sheep's clothing. This wolf comes as a wolf. And again, very memorable. And when I think back in the 80s, he came on in 86. When I think of a lot of his dissents in the 80s and 90s, they were very clever, and they might not have had as much nastiness. And I'm wondering, since you have reduced this to a science of sorts, Rick, if you think he got nastier as he grew older, frankly.
I don't think that shows up in the numbers. If you look at the opinions that are described as sarcastic or caustic, they span his time. But I do think, in speaking to reporters like you who are in the courtroom and cover the court, there definitely was a sense in his last few years he was angry. So Jeff Toobin called him the Fox News justice, which I thought was not entirely fair, reducing him to a caricature. But he was certainly angry, and there was a moment when the Supreme Court was announcing some opinions near the end of his last full term on the court, where it was a death penalty case called Glossip, where the majority opinion was given. Justice Breyer gave an oral dissent, which is a way that a justice signals, I'm really unhappy with this. And then Scalia, who concurred in the majority opinion, chose to weigh in and gave remarks about a same-sex marriage case that had been decided not that day. And so, there were some questions about whether he was just so unguarded that he was just letting it all go. But if you read his written opinions to the end, there is some nastiness, but it doesn't seem like he lost a step. I don't think there was anything indicating that he was not functioning, with all of his mental capacity. But he certainly seemed to be less guarded.
Yeah, and I was more thinking the nastiness factor. This moment that Rick just described, it was, again, this was in 2015. It was the day after the Obergefell same-sex marriage decision had come down, and he was still steamed over that. And the justices issue a death penalty ruling in which he's on the winning side. He even wrote a concurrence. But as Justice Breyer is reading his dissent from the bench, you can see more steam coming out of Justice Scalia's ears, and he gets so mad that, and he used to speak off of a text when he dissented from the bench. He doesn't have any kind of text in front of him, and he starts to say, I don't like what he said, and I definitely didn't like yesterday. So he just goes on and on and on. But again, it's, I thought in those instances, he certainly did not help himself. But one way where he was communicating and having an influence is that a lot of these were picked up. And you cite a study by, I think, Frank Cross, where you say that he had like twice as many citations among lower court judges. So what kind of value do you see in that he was picked up? Was he picked up for the law he was espousing, or more the quip he was making?
Yeah, so this is what's really interesting. And this is why the Scalia Court didn't work. David Cole, who I think is actually speaking across town today at a competing event, which I David Cole had a great line about Scalia right after he died. He said he was the most influential justice without influence in Supreme Court history. And so what did this mean? So there are kind of two ways to think about, traditionally to think about which justice has the most influence. One is, do they write the most majority opinions in important cases? And on that measure, Scalia did not. You can count really on one hand the number outside of criminal procedure of his opinions, his majority opinions that were in blockbuster cases. Heller would be the one example, which I think we're going to talk about, the gun case, and criminal procedure cases as well. But he didn't write most of those big majority opinions, even when he was on the majority side. The other way of thinking about an influential justice is, are you the swing justice? Are you the one who sometimes with the liberals, sometimes with conservatives, and that's O'Connor or Kennedy or Powell or Byron White, different justices at different times. He wasn't that either. So how did he have influence? I would say, and this was the original theme of the Scalia Court, the book that was not written, was he moved the middle of the court. That is, he took his ideas and he took a fairly extreme position on how to interpret statutes and how to read the Constitution. And he caused everyone to change how they spoke about cases. And he, through the sheer force of his intellect and his writing style, he was able to get attention for his ideas in a way that a bland writer with less bold ideas would not have been able to. And so there was a few years ago, there was a Harvard Law School, they put on like a comedic review. And so they made a video, and the video was called Rather Read. And it's about all of these liberal law students sitting there reading Justice Breyer and reading Justice Ginsburg. They'd rather read Scalia because he's got the style. And as a casebook editor, I put together textbooks for law students. Of course I'm going to include that Scalia excerpt. I want to keep my students awake, when they're reading about a 9-part test and this and jurisdiction and all that. Scalia would write in an accessible way. So that is how he got influence, much more so than, say, Justice Thomas, who has not identical, but very similar views about how to read the Constitution and statutes, but not nearly the kind of following that Scalia had. And Gorsuch I think, is trying to be like Scalia. I don't know if he's going to make it. So just to give one example, and again in that partisan gerrymandering oral argument, talking about, well, what's going to be the standard to know how you should draw district lines? And he said, I don't know, it's a little like my steak rub. A little of this, a little of that, a little turmeric. And according to Nina Totenberg, who was in the courtroom on a podcast, she said he was kind of like mugging for the cameras. There's no cameras, but for the audience. He thought that was funny and kind of fell flat. So it's hard to be Scalia. And even when Scalia was there, it was hard to compete. He would always win the contests of who gets the most laughs. Breyer would actually get a lot of laughs, but those would be more for his self-deprecating humor, while Scalia would be making comments that would be aimed at someone else, I think.
Okay, so let's segue to Heller, which is which was a majority opinion, and it's very relevant today because it, for the first time, declared that there was a Second Amendment right for individuals to bear arms. As probably many people here know, the Supreme Court had said, and it was common understanding, that the Second Amendment didn't protect an individual right, rather it protected a state militia right, like a National Guard. But Justice Scalia, with no concurrences on his own, with all five of the conservatives together, was able to write that, and he did what he cast as an originalist reading of the Second Amendment. Now, Justice John Paul Stevens, who wrote for the dissenters, also cast what he had as an originalist reading of the Second Amendment. And you deconstruct both of those. So where do you end up on Scalia's argument? Did you feel like it was just a hunter who wanted to enable hunters to be able to bear arms?
Well, Heller is very interesting for two reasons. Number one, I think both liberals and strong originalists believe that it was not fully an originalist opinion. So he didn't just look at what are the words a well-regulated militia. There's the prefatory clause of the Second Amendment and the rest of the Second Amendment and try and put it together and what did the founders think. But then he goes on to post-ratification history, and he's talking about lower court cases, and he's talking about how to achieve a balancing of interests. And so he'd been criticized or praised as a living constitutionalist, although he didn't admit it. There was much more in that opinion than just trying to figure out what the words would have meant to people in the 18th century when these things were being worked out. But the other thing to say about Heller is that liberals hated the Heller opinion when it came out. Here was a radical change. For the first time, the Supreme Court is saying the Second Amendment gives people an individual right, which means you can sue when someone takes away your right. And people thought this is a disaster. Gun control laws are going to be struck down right and left. And in fact, that's not what happened. There's a line in there, and I don't know if that was the price to get Justice Kennedy's vote or some, I have no inside knowledge, which basically says we're not calling into question laws that prevent felons or the mentally ill from getting guns and reasonable regulation. People can't get a bazooka and all these kind of things. And in fact, just last week, Justice Thomas dissented from the Supreme Court's decision not to hear a case out of California involving a 10-day waiting period for firearms. It was brought by people who already owned firearms and wanted to buy more. And they said, what would be the reason for giving a waiting period for us? We've already gone through this. And Thomas says, look, if this were any other right, if it were a 10-day waiting period for an abortion or a 10-day waiting period before a newspaper could publish something, of course the Supreme Court would get involved in those cases. But so what Scalia managed to do was he managed to both diffuse this energy about, are we going to have a constitutional right? He said, yes, we are, but then found a way to allow for balancing. I mean, that seems like a great political living constitution compromise. I think Scalia would not be very happy to hear someone describe it that way, but I think that's how it's worked out, much to Justice Thomas's dismay.
That's right. I just realized that I need to offer a reminder here to our audience. This is NYU Law School's Brennan Center for Justice program, and we are talking to Rick Hasen, UC Irvine law professor and author of the new book, The Justice of Contradictions, Antonin Scalia and the Politics of Disruption. I'm Joan Biskupic, your moderator, and in 10 minutes we will take questions. That's for the tape, not for all you here. It is so interesting what's happened on guns because Rick is exactly right, and it might be why he was able to get the five to be together, because there were these caveats about what regulations can still be there. The other area where he is so well known, but certainly didn't get a majority, but neither did the Chief Justice, is in the area of gay rights. And one of his last decisions, his last dissents, was the Obergefell one in summer of 2015. And I saw him after that. I've talked to him a couple times by phone leading up to the time that he passed away, but the last time I was actually in his chambers was in August of 2015. And he had lost King versus Burwell, which was the second Obamacare case, and also the Obergefell case. And he was just so mad and about everything. But he had this thing about gay rights. This was a very, he dissented with such passion in 2003, the Lawrence case, the same-sex relations one. He dissented in Romer back in 1996. And he really did, this bothered him a lot about Justice Kennedy. He and Justice Kennedy parted ways on many social issues. But this was really something that he could not abide. And you talk about it a little bit. You talk about it a little bit in terms of the roots of his dissent. But what do you chalk it up to? And how do you understand what message he sends through his dissents in his same-sex marriage case and gay relations?
Yeah, so part of me wants to just turn it back to you, since you did write the real biography. I don't know what made him tick. I can only look at what he said. Mm-hmm. And there's a question about where he personally stood on these issues. And he gave a very interesting interview to Jennifer Senior, who was at that time at New York Magazine, mm-hmm. Where she said, well, it seems like history is moving against your position. How does that make you feel? And he said, it doesn't bother me. He said, things may be passing me, and there's Scalia standing athwart it, or at least standing athwart it as a constitutional matter. And then he says, when I'm gone, I'll either be supremely happy or supremely sad. And then they go into a discussion about the devil and hell, and again, different road. But I thought I was really caught by this line, at least as a constitutional matter. So it was a question about whether or not he harbored anti-gay animus. He wrote a number of dissents, including one in a case called Lawrence versus Texas, which was in the 1990s, where he talked about the homosexual agenda, which that language was...
You're talking about the 2003 one, I
2003,
think.
that's right. And he also said that the reason that there's so much political power for homosexuals was because basically they don't have kids, and so they have lots of disposable income, and they can use it on politics. So kind of a very he had a very definite view about this, and I got a lot of pushback from some people who were more sympathetic to Scalia, who read the mm-hmm. Manuscript, and they said, no, that Scalia was just saying this is a matter to be decided politically. Not a matter to be decided by the courts, that if states want to pass these laws, that's okay. But just a few years before he died, he was confronted after a speech he gave in Princeton, where a gay student said to him, I'm very offended by you comparing laws against homosexuality to laws against murder. And he said, if I can't have feelings of moral outrage against murder and against homosexuality, what good is it? Basically, that he again, near the end of his life, compared laws against homosexuality to laws against murder. So I think, just from the outside signals, this was an issue that really bothered him, and he thought that it was he predicted early on that the recognition of same-sex rights was going to lead to same-sex marriage. He was right about that. But then he predicted a kind of further mm-hmm. deterioration of the morality of society as he saw it, and thought it was taking us down the wrong road.
Yes, it was in 2013 in the Windsor case, where in his dissent, that was the case where the justices, by a majority, struck down the Defense of Marriage Act, the federal law. And again, it was Justice Kennedy. And Justice Scalia writes in dissent, this is going to lead to same-sex marriage. And frankly, many of us didn't quite believe that would happen, but sure enough, lower court judges immediately picked it up and ran with it, and that's where we ended up then just 2 years later, which is amazing. The other area, thanks. The other area that I want to talk about before we open it up to questions, and we'll have questions in just about 5-10 minutes, affirmative action and racial remedies. He, again, toward the end, he would say, I think I have another great line that you used from his oral arguments that I think would be a terrific one for us to talk about in terms of the original meaning of the Equal Protection Clause. It's 2005, and the court is back hearing again the Fisher versus University of Texas at Austin case. And it has to do with Texas's, the flagship university would take into account several characteristics for applicants, including race, socioeconomic background, creativity, all sorts of things. But that was just one of the factors. And it's toward the end of the argument. I remember being there, and I remember thinking, he's sort of wandering into a territory that I'm not sure he wants to go into. And he starts talking about, quote, really competent blacks versus essentially not competent blacks. And it degenerates pretty quickly, and that became sort of the news story of the day, and that's when a lot of people were calling saying, isn't this worse than ever, kind of question. And you use it both to show him as the kinds of things he would say, but also to talk about the original understanding of the Equal Protection Clause that he was saying he was espousing, but you differ with.
Yeah, so let me take this on two levels. One, there's a question, he was personally, you can tell from what he wrote, opposed to affirmative action plans. It was not just this. In a Voting Rights Act oral argument, which I quote, a 2009 oral argument, he's talked about why do we have the Voting Rights Act? It's the perpetuation of racial entitlements. No, everyone's afraid to vote against the Voting Rights Act. Even the name sounds great. And so he had this kind of aversion to, he believed that gays and minorities had too much political power. Ordinarily he wanted to let the political process run itself, but not when it came to those groups. As I thought, there was a double standard there. But on the question of original meaning of the Equal Protection Clause, the Equal Protection Clause, this comes out of the Reconstruction Amendments after the Civil War. And how do you read what it means to give equal protection? Well, one way to read it is you just look at the words, and the states can't deny people equal protection of the laws. And he said, well, that doesn't protect sex discrimination because, nobody believed that it did at the time. So he looked not just at the words, but at what the social understanding was at the time. But when it came to race, he would just look at the words. And so there were, for example, Congress passed laws giving preferences to African Americans, to newly freed slaves, giving them government preferences at the time that the Equal Protection Clause is ratified. And if you want to talk about a contemporary understanding, the contemporary understanding was that was okay. It didn't violate the Equal Protection Clause, and that's an argument why affirmative action, even under a certain kind of originalist understanding, could be constitutional. Well, maybe Scalia didn't know about this. Well, we know Scalia would sometimes hire liberal clerks, called them counter clerks, to keep him honest. If he could find what he considered to be a principled liberal, he'd bring him in. So one year he brings in a guy who later becomes a law professor named Gil Seinfeld. And Professor Seinfeld, when he's a clerk for Scalia, writes a memo and says, here's all this historical stuff. Here's all this proof. You should, in your cases, address this. And if you have a reason for not following it, explain why. And he never did. And I go through instance after instance in the book, and I think you pointed me to some of them, where when Scalia would be pushed, whether it's by Alan Dershowitz or by someone at a federal society meeting, how do you reconcile this with originalism? He would make a joke. He'd say, like Sarah Palin would say, let me get back to you. Or at the federal society, when he said, no, we're not talking about that. Next question. And he would just demur and defer. In fact, somebody pointed me to he was asked by the University of Chicago Law Review to review Jack Balkin's book, Living Originalism, which is kind of a liberal take on originalism. And his response in the letter was, I can't review it because I'm never going to read it, because I just have no time. And he said, I'm going to follow Disraeli's maxim, which was, never complain, never explain. So he at least never explained. And I thought there were lots of contradictions in his originalist approach. Sometimes he looked just at the words, sometimes he looked at the social context, and some of his cases he didn't bring it up at all. And so one of the criticisms of Justice Scalia is that he was not Scalia enough.
You know, it's funny, you use in that section, you referred to a comment actually that he had made to me about Bakke and Lewis Powell, the original affirmative action case from 1978 where the justices, by a narrow vote with Lewis Powell writing, endorsed affirmative action for the first time. And Justice Scalia talks about, well, that was Lewis Powell, who was never going to identify with working class whites, which I don't necessarily buy, but I did notice through my conversations with Justice Scalia, he never really shook the idea that he was a boy from Queens. He thought of himself, there were two things that he didn't get in life that he really wanted. And working backwards, the second was in 1981, when Rex Lee was chosen to be Solicitor General for Ronald Reagan, he really wanted that job desperately. He probably wouldn't have ended up on the Supreme Court if he had taken that job, but he really wanted it, and he was edged out by Rex Lee. And Maureen Scalia said it was the only time she ever shed tears over his not getting something. But he also didn't get into Princeton. When he was a young man, he was, smart. He had done well in high school, and he didn't get into Princeton. And he chalked that up. He said they didn't want an Italian boy from Queens, which I thought that, for as successful as he had ended up being, he goes to Harvard Law School, that's still stuck in his craw. So maybe there was a little bit of the, I'm being edged out.
Yeah, well, he talked about, in that Lewis Powell quote, the Polish factory worker's kid who was being squeezed. He said, that's who's suffering. And this is why I say that he was a neo-Trumpian disruptor, because he was a populist, a conservative. He believed he was doing stuff for the little guy and helping to stop government oppression. And a lot of that comes out, which we didn't talk about in his criminal procedure cases, where he kind of takes the side of the little guy. And yet, you can find a whole host of opinions on issues related to consumer rights, arbitration, class actions, the ability to actually, the little guy to get together with other little guys and sue, and he was, shutting the courthouse door. And so this is why the book is the Justice of Contradictions, because there was this side of him that was anti-elitist. He goes after the Ivy League elites on the court, and of course he is one of them.
Oh, completely.
He was as well educated, and he was very much like them, but didn't, in his writing, he did not come across like one of them.
I'm going to ask you one last question. It has to do with his death, and then we're going to take questions from the audience, and then we'll come back and finish up. But I remember I talked to him by phone maybe about 3 weeks before he passed away, and he, one of his grandchildren were going to Rome or something like that, and he wanted to know when his dad had been naturalized. And he said, "Do you have that document?" I said, "Yeah, in the basement under the ping pong table with the Scalia boxes." So I went and got it and called him up and said, told him the date, and I said, "You want me to run it over to you?" And he said, No, I'll take it and I'll pass it on to her. And he said, "I owe you one, Joan." And I thought, when he died, I had a million different thoughts, but in the back of my mind, I was also thinking, damn, I would have wanted to cash that chit. I would have wanted to have found out something. So, but you spend a whole section at the very end on his unusual death. Just to refresh the memories of anybody who didn't quite recall, February 13th, the afternoon, he's hunting at a remote Texas lodge, a very fancy place. He doesn't get up. He's flown in the night before after a very long trip to Asia, which probably didn't help whatever his health condition was. And when his hunting partners went to get him, he had died during the night. And there was a lot of talk in the news about a pillow being over his head. And Rick actually spends some time talking about the conditions of his death, and then you give your conclusion.
Yeah, so no foul play. No, I explained that for a couple of reasons. One is your book only goes through 2009.
Nine. It was published in 2009.
So I wanted to kind of bring us up to date. But more importantly, it kind of showed the polarized times we were in. And so I quote Alex Jones from InfoWars saying, "There better not be an autopsy." And Donald Trump, the candidate, speaking on the Michael Savage radio show saying, "Something's fishy here. We've got to get into it." And if you actually look at what happened, the reason that there was this conspiracy theory is the guy who found him at this ranch, he was at this exclusive hunting ranch, said he found Scalia with a pillow over his head. So pillow over his head, like he had been suffocated. And then they followed up with the guy, and the pillow was over the top of his face up here. He had 3 pillows stacked and one on the top. And I thought Scalia would have appreciated the ambiguity of pillow over his head versus pillow over his face. But it was just, it was Scalia went, we don't know who paid for the trip. He was very secretive about those kinds of things. He wouldn't release any more information than he had to. He was with this group of elite hunters that traces itself back to the 1600s. One of the people, I think, who was hosting had a business before the Supreme Court a few years before, so there were all kinds of questions about payments and things like that. So it's just that he kind of died as he lived in a somewhat contradictory way. But there really was no indication that that there was any foul play. In fact, they did not do an autopsy, but the family was very satisfied that it was natural causes. And he had, there's a list of conditions that he had. Heart problems, all of this. One thing I can say is that just a week before, he had a torn rotator cuff in his shoulder area, and he was found to be too weak for surgery. So that's how ill he was. And yet information was not made public, as opposed to Justice Ginsburg, who, when she had cancer, released detailed information to the public about her condition and her treatment.
That's right. We're going to take a break for questions. Is there a microphone, or how do we do that? Is there, Wendy? Okay.
You want to ask me something in the meantime?
Here we go. Oh, there it is. Okay. Give somebody. Go ahead. You can stand up over there. Then people will hear you a little better. Thank you.
Just going to take a cursory view of the room before I pose the question. I got my answer. Okay. As a woman of color, my understanding, and an attorney, a former prosecutor, it's my understanding of Scalia, of course, is colored by my background, my experiences, my gender, my socioeconomic status. And what I've never been able to understand, and to a great degree bothers me about our examination of Scalia and his decisions, especially regarding people of color, is that we seem to glamorize his humor, glamorize his idiosyncrasies, but we don't focus on the fact that he was an Orthodox Catholic is probably the reason why he was so vociferous in his criticisms and negation of the rights of people of color and persons who were gay or lesbian and transgender and so forth. And so I don't understand why, as a legal community, speaking as an attorney, we are unable or refuse to demystify this conception that we cannot divorce politics from the law. It is impossible to render a decision, especially if you're Antonin Scalia, and not, in one way or another, incorporate those values of a boy from Queens, with a Catholic mother and father, with experiences in his concepts of upward mobility or the absence thereof. And so when are we as a legal community going to understand that there are political questions presented before the court, and that every single member on that court has a political paradigm that colors their decision?
Thanks for the question. I'm going to have you address it, but the one thing I would say, I think you've nailed his background certainly, but and he wore his Catholicism, rather openly and boldly, and talked a lot about being Catholic, and with his law clerks who were Catholic, would always want them to make sure they went to Ash Wednesday services and all that. But just as a counter to that, it is Anthony Kennedy who gave us, same-sex marriage, who voted to uphold abortion rights, and he's also Catholic too, and so was William Brennan. Scalia was a certain kind of Catholic, that I would say. Now, why don't you pick up the larger political questions?
Yeah, and let me say,
thank you.
If you look at my book, you'll find very little about Catholicism in there, because I did not interview him 50 times like you did. I didn't have a personal relationship. This is a book more about his ideas. So I don't know what made him tick. I don't know what the inner sociological thing is. But I think I agree with the main thrust of what you're saying, which is that Scalia purported to have the answer for how to decide difficult cases. you would look at the text of the statute, you would look at the original public meaning of the constitutional provision, and you would apply these neutral principles, sometimes kick in a canon of interpretation, and you'd get your answer, like it would be spit out, as if there is a right answer. And what I say is that Scalia was influenced by his values the way all of the justices were. He was no more idiosyncratic in his views than the other justices were. The difference was he presented himself as doing law and everyone else as doing politics. And I think that's where, and the aim of my book is to show that that's not true, that you can't divorce the political from the legal on the very difficult questions that the court has been deciding. And so I think part of my project is to demystify Scalia, to say, yes, he was this charmer, yes, he was this larger-than-life figure, but in the end, his project of originalism and textualism failed. It failed to come up with something that would cabin discretion. In fact, it usually, at least outside the criminal procedure area, leads to very conservative results in his hands. Put it in John Paul Stevens' hands, it comes out very liberally. So there's something else going on besides just neutral application of principles.
Thank you.
Yes.
Hi, I'm John Cowell with the Brennan Center. Thank you for both of you for participating. So, at the time of his death, many people recalled anecdotes from Scalia's life, and in particular, his early years on the court and how he single-handedly sort of snatched defeat from the jaws of victory in terms of the emerging conservative court. He ended up kind of pushing away O'Connor, pushing away David Souter, in particular in the Casey case. Really, when someone might have played a role in really building a durable conservative majority, he ended up actually, some argue pushing them into a more moderate stance on not just abortion, but other issues. I'm curious about your thoughts about that, and in particular whether Neil Gorsuch is sort of actually following the same template by there seems to be stories that he also has managed to alienate people, fall flat, make people feel like he thinks he's smarter than they are. So I'm curious about whether you really give credence to these views.
Yeah, so I actually talk about the Casey question because there are a few books that have been written, including one by Jeff Rosen, that makes this claim that Scalia could have had abortion rights curtailed much more, but his personality and his interaction with others pushed away O'Connor. My reading of the publicly available material, including the work of Linda Greenhouse and Reva Siegel, is that that's not the case. That at most, at one point, I think you talk about this in the book, in your book as well, that Scalia goes to talk to Kennedy to try to convince him to change his mind and can't get him to change his mind. Scalia rejected the idea that he ever lost a case because of his sharp tongue. And there really is no evidence that I could find show it. He definitely lost the case for that reason. But I think how much more could he have done if he had used honey instead of vinegar? He was one of the smartest justices we've had on the court in the recent years. And had he toned it down, I think he might have written more majority opinions. Had he compromised more, he might have. I don't know if you have different observations on it.
I think this is a great question, and it really goes to how much the interpersonal dynamics can affect that place. And Justice O'Connor had a little bit more of that kind of reaction formation you're speaking of, much more than David Souter. I think David Souter showed up ready to vote the way he voted, frankly. I think anybody who listened to his Judiciary Committee hearings in 1990 would have seen the threads of that, what he really was. And he wasn't the, quote, home run for conservatives even when he showed up. But I think Justice O'Connor resisted Justice Scalia, just as she also did William Brennan from the other way early on, because I think he thought that he could maybe persuade her a little bit more than she was ready to at that time. It's very subtle, but it's like any group of nine. It can have an effect, and it can definitely have an effect at the margins, maybe not in the big cases that we're talking about here, like same-sex marriage and abortion, but it's real.
I don't know if you want to wait to address the Gorsuch question.
Oh, we'll say something at the end about Gorsuch. Yeah. Yeah. Yes, in fact, this is good. I think we have time for 2 more questions. Okay, great. Thank you.
Hi. So I'm currently a student, and as college campuses are becoming increasingly polarized, and in fact, it's really hard to maintain a social life that's separate from politics. So considering Justice Scalia's really close and unexpected friendship with Justice Ginsburg, what would you say Justice Scalia's thoughts would be on finding friendship and civility with those who think differently from you while still keeping true to your convictions?
Wow, that's a really great question. I have bad news. So Scalia and Ginsburg had a very close friendship. They would spend New Year's Eve together. There's a picture of them riding on the elephant. And why was he in the front of the elephant? She said because they said the heavier one had to go in the front. You
Right.
know, she weighs 80 pounds maybe. I don't know. She's very light. And then he became friends with Justice Kagan. And he took her hunting because she had promised some senators that she would try out hunting so she could get a better sense of how that all worked. And I was at a talk that Justice Kagan gave in Chicago a few months ago, and we were after the talk there was a dinner, and she took some questions, and someone asked a very similar question. She said, "Who are you friends with on the court?" And she talked about how she had this friendship with Justice Scalia, and someone said, "Well, what about anyone else?" She said, "I loved Justice Scalia," and just left it at that. And I think it was very unique because Scalia was such a charmer. He was able to get over that and keep those relationships. But I think it's very hard. I think especially now in these polarized times, he came on the court. It was much less polarized. I don't know if he came on the court now, how things would be.
Well, and also, just to fill in the blanks about how he and Ruth Bader Ginsburg got to know each other, they were both on the DC circuit, and they would swap, again, former law professors both, they would swap their opinions and have each other read them before they deliver them, just to kind of do editing. And they both loved opera, of course. So it was fostered earlier on. Justice Kagan is pretty smart about, well, first of all, I think she enjoyed his sense of humor, but she also knew as the junior justice, it'd be good to get to know some of these guys a little bit more, and if it means going pheasant hunting, she could do that. Thank you.
Thank you.
Hi, and thank you both for an amazing event. I'm an associate editor at Just Security and a research scholar at the NYU School of Law. I had a couple of quick questions. One is that I was wondering if maybe you were missing a sort of meta-positive of Scalia's intellectual contributions to the court, in that it seems that prior to Justice Scalia, methodology was sort of a grab bag for many justices, and they'd pick and choose whichever methodology suited their result. And afterwards, even liberal and sort of living constitutionalists had to at least clarify that position and sit it up front. And sorry, I just had one other quick question, which is that for all of Scalia's venom and sort of the antagonistic tone he took in his opinions, could it be possible that some of that was just making what used to be private and bringing it into the public sphere? So if you look at Baker versus Carr, Justices Douglas and Frankfurter made Justice Whitaker sick with the debate over that. And so maybe it's a good thing for things like that to be more out in the open. So,
Good questions.
Go ahead.
Answer all of them briefly.
So, I don't know that it's better to be out in the open. I think some things are, when you're a Supreme Court justice and you're sending a signal to law students, this is how you communicate when you disagree. I think that's a problem. I'd rather them keep it among themselves. And the first question about how he's changed the methodology, he certainly changed how people talk about interpreting the Constitution and how they talk about how you read a text. Justice Kagan famously said in 2015, "We're all textualists now." But I think in the really hard cases, the ones that make the front page of the New York Times, whether you call it an originalist or a textualist analysis, it's not going to change the outcome of those cases. It's changing the outcome of whether a fish is a tangible object, which was a Supreme Court case that they had to decide, where Justice Kagan cited Dr. Seuss, One Fish, Two Fish. But in the really big cases, King versus Burwell, it's not going to be methodology that's going to decide those cases.
Jesse, you get the last audience question.
I wanted to just ask you, you mentioned at the very beginning sort of a view a few years out as opposed to maybe decades or 50 years out. And I was thinking of, we're now approaching that time with Roe v. Wade, and obviously many legal scholars across the political spectrum are less than thrilled with the way Roe v. Wade was reasoned, even if they like the outcome. And I'm wondering if you have thoughts on how you see the development of response to Heller over the coming years. I think it was Judge Wilkinson who called it the rights Roe v. Wade shortly after it came out. And do you think that the sort of legal, the reaction from the legal community and legal scholars and lawyers over the coming years is going to change with regard to Heller in the same way it has with Roe v. Wade?
Well, I think what happens is that so much is going to depend upon who's on the court. And let me just make something obvious, which will segue us into the last set of questions. We now have a situation for the first time in decades at least, where all the conservatives appointed on the court were appointed by Republican presidents, and all the liberals were appointed by Democratic presidents. And on the tough cases, they're completely divided. And so I think increasingly we're going to think about the Supreme Court as the Democratic justices versus the Republican justices. And the court's going to be seen as more of a political polarized institution. And so what happens with Heller, what happens with Roe v. Wade is going to depend on, tell me who's president when Anthony Kennedy decides to leave the court, and what the numbers are. And I think there's going to be much less middle ground. I think just as Scalia pulled the conservatives to the right, and I think he did, kind of move the middle, I think there's a kind of a counter reaction that's coming on the left. And you're not going to have more moderate justices being appointed by Democratic presidents, at least if the Democratic base has anything to say about it. You're going to have prize fighters from both sides. And so I'm not optimistic about the court and the independence of the judiciary and its separation of law from politics going forward.
Yeah, and what it'll take, though, if the Democrats want to name someone who would be a counterweight to kind of Justice Scalia or Justice Gorsuch, you're going to have a completely different Senate, not just
well,
White House.
You just need it to be 51 votes or 50 votes plus a vice president. We know now that it's, President Obama tried to play it safe with Merrick Garland. Now that didn't work, and a lot of people are rethinking that just a few years later, that he should have picked someone bold and someone who could have rallied the base and made it more political. So, yeah.
You end your book with something, the way we'll end today, and we'll respond to the question from the gentleman about Neil Gorsuch, who succeeded Justice Scalia after his seat, of course, was kept empty for more than 400 days through Mitch McConnell getting all his Republicans to unite behind the idea that the next president would name it. And lo and behold, it turns out to be Donald Trump, and on comes Neil Gorsuch. But the way Rick closes his book, last time for you to see it before we, he writes, had Scalia's jurisprudence on the law of politics and political power gained the court's full support, it would have threatened some core democratic principles. Individuals, corporations, and other domestic entities would be able to give unlimited contributions directly to candidates for offices. Legislatures would be able to draw legislative districts for full partisan advantage. Politicians would be able to use public employment decisions to reward the loyal and to punish those who belong to the wrong political party. State legislatures would be allowed to make it harder for some people to register and vote, so long as the laws didn't burden most people. And you go on about consumers and labor unions having less power, and you say it's a deeply conservative vision of politics. And then your last line is, and one that could well come to pass in years to come. Is that a comment on Neil Gorsuch and where you think we're going politically, or where you think the younger members of this court skew the Republican appointees? What do you see happening?
Well, Trump is picking his judges from the Federalist Society. So I wonder, turn this around and ask you, could John Roberts get confirmed today, or is he too moderate? That's a question that would have been absurd to ask a decade ago, I think.
I think John Roberts could get confirmed under just about any circumstance.
Really? Okay.
And the premise, I don't know if I even buy your premise, just because he upheld Obamacare?
Well, because he was not a kind of movement conservative the way Neil Gorsuch wrote after Justice Scalia passed, just this ode to Scalia and his views of interpretation. And it's pretty clear that the people who are being chosen are really true believers who will follow in Scalia's footsteps on the issues that matter the most to the conservative base of the Republican Party.
Yeah, a David Souter won't slip in. Let's just put it that way.
So I think, as I said, I think things are going to be more polarized, and there will be a time, I think, when Democrats control the Senate. If that happens when Trump is president, I think they shut down judicial appointments, at least for the Supreme Court, if not for appellate court offices. And if a Democrat comes in as president, I think there are going to be a lot of people saying you do need a counterweight to the new Scalias that are coming on the court. And so what I think more than anything else is that the court is becoming more of a reflection of American society, and rather than something apart from American society that could help keep us together. There's a core of justices that are looking for compromise right now on things like the travel ban. The Chief and Kennedy and Kagan and Breyer seem to be kind of the middle. I don't know how long that middle lasts. I mean, that used to be the Senate, right? The Senate used to have a middle where they would gang of 14. I don't know. I mean, I really feel like things are going to, the forces are pushing them to two different camps. And that's not a good model for an independent judiciary.
Let me just wrap this up for our online listeners. Our thanks to Rick Hasen and his book, The Justice of Contradictions, Antonin Scalia and the Politics of Disruption. I'm Joan Biskupic, and please keep up with the work of the Brennan Center online at brennancenter.org. Follow them on Facebook and Twitter, watch their videos on YouTube, and listen to the Brennan Center podcast on iTunes. Thank you all for coming, and the most important thing any author wants to see is somebody pick up the book and ask for a signature. Thank you all. Thanks. That was great.